Hey everyone, welcome back to The Explainer. Today we're diving headfirst into some seriously fascinating and honestly pretty controversial source material. We're looking at a viral interview between commentator Viva Frei and constitutional lawyer Shawn Buckley. And don't worry about getting bogged down in legal jargon, because we're going to break down their entire conversation step by step, translating the complex legalese into plain English so you can see exactly what they're arguing.
Now, this entire interview really hinges on one massive, provocative question. Is a UN declaration going to destroy Canadian property rights? Now, I want to be absolutely clear right out of the gate. We are not taking sides here today. Our goal with this explainer is just to objectively map out the anatomy of Buckley's argument. We're relying purely on the claims made in that interview so you can understand the exact legal theories being put in front of the public right now. All right, so here is our roadmap for today. We're going to cover the core claims, COVID-19 and judicial notice, defining UNDRP, the property rights impact, the Richmond case, and finally, a constitutional warning. We'll trace how Buckley builds his argument, going from past legal precedents all the way to a very stark warning for the future.
Okay, jumping into Section 1, the core claims. Who exactly is Shawn Buckley? Before we get into all the heavy constitutional theory, we really need to understand who is making these arguments and where his perspective is actually coming from.
So, our primary source, Shawn Buckley, is a constitutional lawyer with 32 years of experience under his belt. In the interview, he talks about his heavy involvement in the National Citizens Inquiry. Buckley firmly believes, and this is based on literally decades of fighting the government in court, that the legal system is heavily rigged against everyday citizens. And that inherent skepticism? Well, that's the lens through which he views every single legal development we're about to discuss.
Moving on to Section 2, COVID-19 and judicial notice. Setting the baseline. So before tackling property rights, Buckley actually sets a baseline for his argument by looking back at how Canadian courts handled recent pandemic mandates. To really get his point, we have to understand a specific legal concept called judicial notice. Buckley defines it in the interview as a situation where a court accepts a fact as universally true without requiring any expert evidence or proof to be submitted. It's kind of like a judge just accepting that the sky is blue. They don't need a meteorologist on the stand to prove it. But here's where it gets interesting. According to Buckley, the courts aggressively misapplied this concept during the pandemic. He argues that courts completely bypassed standard safety and efficacy proofs for COVID-19 vaccines. They basically deemed them safe without requiring the usual clinical data to be submitted. On top of that, he claims this legal shortcut was actually weaponized against parents in family law custody disputes if they happen to oppose the vaccine for their kids. So, for Buckley, this establishes a clear, very recent precedent of government and judicial overreach, and that paves the way for his next massive claim.
Which brings us to Section 3, defining UNDRP, a new international treaty. Buckley connects that perceived willingness of the government to just bypass standard legal norms directly to this brand new international treaty.
So what exactly is UNDRIP? It stands for the United Nations Declaration on the Rights of Indigenous Peoples. Now, usually, international declarations don't actually mean all that much until they become domestic law. But Buckley points out that the Canadian government passed an act to fully implement this treaty domestically in 2021, meaning it is now legally binding on the government.
Let's look at the timeline Buckley lays out here. The UN initially adopted this declaration way back in 2007. Then Canada began ratifying it in 2019. And then, just 2 short years later, in 2021, the Canadian UNDRIP Act passed, with 210 to 118 votes. But what Buckley emphasizes over and over in the interview is how quietly this all happened. Both he and Viva Frei express absolute astonishment that such a monumental shift in Canadian law happened without massive public debate or, front-page news coverage. All right, Section 4, Property Rights Impact, the impact of UNDRIP. This right here is the absolute crux of this explainer. This is where Buckley makes his most alarming claims about how this treaty could impact everyday homeowners.
Let's actually look at the exact text they are reading from. Article 26 of UNDRIP states, and I quote, "Indigenous peoples have the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired." Now, Buckley anchors his entire theory on this objective text. He argues that in Canada, the phrase traditionally owned or occupied essentially covers all populated land in the entire country. To really grasp his concern, we've got to contrast 2 legal concepts he talks about. On one side, you have fee simple ownership.
Think of your own home, or maybe the house you grew up in. That is the traditional right most homeowners think they have, the right to use, control, and sell your own property without restriction. But on the other side, Buckley argues that UNDP introduces an Aboriginal title overlay. He claims the government is now legally obligated to place Indigenous ownership rights directly on top of existing private properties. And crucially, he notes that courts have ruled this title cannot be alienated or sold. So, according to Buckley, your standard ownership is suddenly diluted by a superior title that you literally cannot buy out.
And here is the core metric Buckley focuses on: 3 to 5%. He argues that through this specific legal mechanism, special, inalienable constitutional property rights are being granted to a very small minority of the population. And he claims this fundamentally alters the equality of property ownership across the entire nation.
Section 5. The Richmond Case. Real-world impact. Now, you might be asking yourself, okay, is this all just a bunch of abstract legal theory? Well, Buckley uses a specific case study to argue that no, his warnings are actually happening right now.
He points directly to the Cowichan tribe's court action. This was a claim for native title over the city of Richmond in British Columbia. According to the interview, neither the federal nor the provincial governments robustly defended the action against the private land. And even more surprisingly, Buckley asserts that the courts ruled they didn't even have to inform the local residents whose property could be affected.
So, what were the real-world consequences of this case? Buckley argues that Aboriginal title has now been successfully overlaid onto private land in that area, and he points out a glaring logistical nightmare here. It is now entirely unclear how banks are going to handle mortgages if the underlying title of the home is compromised. Furthermore, both he and Viva Frei really highlight that this was allegedly mandated in secret. They claim there was zero prior public notice given to the homeowners themselves until it was basically a done deal. Because of all this legal uncertainty, they cite a truly staggering figure in the interview. They claim that real estate appraisers in British Columbia are already warning that property values in the affected Richmond areas could plummet by as much as 30 to 40%. That's massive.
And Buckley asserts this isn't just some isolated incident in Richmond. He shares another specific anecdote during the chat: the Musqueam Nation deal. He states the federal government recently reached an agreement that covers roughly 2 million homes in the lower mainland of British Columbia. For Buckley, this is hard proof that the legal framework established in Richmond is rapidly expanding outward.
Which leads us into Section 6, the constitutional warning. Societal implications. This is where we need to analyze the overarching political and societal conclusions that Buckley and Viva Frei issue right at the very end of their conversation.
The speakers draw some incredibly charged conclusions from all this data, which, again, we are just reporting neutrally here. They claim this policy effectively institutionalizes what they call property racism forever, creating a permanent two-tier society based entirely on heritage. They argue it deliberately erodes the middle class by destroying the equity people have built into their private homes. Ultimately, they warn this will lead to a massive loss of self-determination for 97% of the citizenry, since ultimate land control shifts to a tiny minority and, of course, the state. In fact, Buckley uses a very specific phrase to frame this. He calls it a new way of doing a communist takeover. He theorizes that instead of just explicitly passing a law abolishing private property, which would obviously cause massive, immediate public outrage, the government is simply diluting property rights with these overlapping titles. He claims they're intentionally confusing the system to bankrupt middle class and make the populace entirely reliant on the state. Which leaves us with a pretty profound question to wrap up our explainer today. If these legal interpretations hold true, how in the world will Canada navigate the delicate balance between historical reconciliation and modern private property rights? It is a deeply complex, high-stakes debate that sits right at the intersection of history, constitutional law, and everyday life for literally millions of homeowners. Thank you so much for joining me to unpack this fascinating source material, and I'll catch you in the next explainer.